Okay, this is the December 9th, 2021 meeting of the Planning and Zoning Commission. I'm just going to call a roll call for the an appointment of alternates. Tony Capone.
I'm here.
Tom Boudreau.
You're muted, Tom.
Can you hear us, Tom? This is just the roll call. If you could unmute and say that you're here.
Can you hear us?
Tom, can you hear us?
Yes, I'm here.
Oh, okay, thank you. Very good. And then I believe we're going to seat our alternate, Paul.
I'm here. Paul Weisgarver's here.
Great, thank you. And myself, Commissioner Scanlon. And with that, we have 5 commissioners present. So voting commissioners present. Okay, so then I guess to begin this meeting, should we open up with citizens' petitions? And this is anything non-agenda related, if you're here to talk about anything that's not on the agenda. Okay.
I have a hand up for Chris Wagner.
Okay, yes, please.
Hi, good evening. Can y'all hear me?
Yes, we can.
Okay, I just have a couple of questions actually. I've never
Sure.
been.
Can you state your name for the agenda?
Yeah, my name's Christopher Wagner.
Okay.
So I'm a disabled veteran and I grew up in Ledyard. I have never actually been to one of these meetings before, but I was looking to start my own business out of my house. And I actually talked to one of the people on the zoning board on the phone the other day. And I meet all the criteria except for the fact that apparently I'm not allowed to use my garage as a business in Ledyard. I was wondering if I could get more information on that or if we could maybe try to change that.
You could come into the land use office and I'll be happy to talk to you about that.
Come into where, ma'am? I'm sorry.
The land use office in the town hall. It's downstairs in the town hall.
Oh, so I can just come in and talk to you about that anytime?
Yeah, we're closed on Fridays, but we're here Monday through Thursday, 7:30, and I'm here till 5:30. So.
All right, and was that Nancy talking?
It's actually Juliet. I'm
Okay.
the planning director. Nancy's next to me.
Hi.
But
Okay. Well, all right. Well, thank you very much. And I will try to come in as soon as I can. All right. Hey, y'all have a good night.
Thank you.
May I please ask just a question? This is Jim Alec. Am I allowed to participate in discussions or until I'm sworn in as a citizen?
Sorry, you broke up there. Did you say participate as a citizen?
Yeah, or I mean, am I allowed to participate in any kind of discussions, or am I still considered to be a citizen? So it would just have to be under a petition if I had any questions or comments.
you could participate in the public hearing as a resident. I mean,
I don't think it's you'd be able to be part of the discussion. I think I got in trouble for that once when I was an alternate.
Okay.
And I should say an unseated alternate.
Okay.
So I think maybe just to keep we'll keep it to that for this meeting if that's okay. But
Yeah,
certainly speak up during the public hearing with any questions, of course.
Okay.
Okay. Do we have any changes to the agenda that I'm not aware of?
just the one I sent you in that revised agenda with the yellow highlighted.
Okay, so we're going to amend the agenda to add the bylaw revisions, which is under new business.
Someone will need to make that motion.
So moved, Tony Capon.
Do we need a
Second.
second? Okay,
Second, Paul.
thank you. We don't need to vote on that, do we? We do?
Yes.
Okay, okay. Then I'll do a vote for amending the agenda. Tony,
Aye.
Paul,
Yes.
Tom,
Yes.
and myself, yes. Do I have everyone as voting correctly? I have,
That's correct.
okay, I had Paul written twice.
Yeah, I know you said you had 5, but we only have 4.
Yeah, thank you for that. There's a correction there. There's 4. Okay. Okay, so with that, we'll amend the agenda to include that item in our new business. And we will move on to the public hearing for application 2113 RA to consider the amendment to add cannabis establishments under the new section 3.5B, uses subject to a moratorium. Okay, so then should I just read this in for everyone? Is that what we would normally do?
Sure.
Okay, so under Public Act 21-1A, a cannabis establishment is a producer, dispensary facility, cultivator, micro cultivator, retailer, hybrid retailer, i.e. licensed to sell both recreational cannabis and medicinal marijuana, food and beverage manufacturer, product packager, delivery service, or transporter. So the Town of Ledyard Planning and Zoning Commission shall not accept or consider any application to permit a cannabis establishment licensed to sell recreational cannabis or medical marijuana as defined by the Connecticut Public Act 21-1. Currently, this states for a period of 6 months. Tonight, I think we're going to decide if that should be 6 or 12 months, commencing from the effective date of December 1st, 2021. The reason for this moratorium is to allow the Planning and Zoning Commission to review this act concerning responsible and equitable regulation of adult use cannabis and the associated regulation of cannabis establishments, and to draft and adopt municipal regulations regarding the retail sale of recreational cannabis within the Town of Ledyard. The expiration date of the moratorium will be June 1st, 2022, unless extended by this commission. At this point, do we have a discussion?
And for the record, we did receive 2 exhibits, sort of too late to add to the record formally, but I could share them. They were from John Rodolico. There's a PowerPoint and another document about legalization of marijuana. So I don't know if you want any of those up on the screen or how you want to do it. Or if he's here tonight to talk about them, I'm not sure.
Is Mr. Radolico with us?
There's somebody on the phone that I don't know who it is, but I didn't see him otherwise. So I'm not, I can't
You're saying
explain them.
it's too late to be a part of the record?
No, it can be introduced tonight. We didn't put it as a formal exhibit because it didn't come in far enough ahead, so.
Oh, okay. I think it would be fine to share that. It sounds like they wanted to contribute something to the record.
Right, bear with me. That didn't work. Let's try that again. Can you see that now, a PowerPoint?
Yes.
Yes. Like I said, I don't I was hoping he would be here to explain what it is, but
So it looks to be a timeline of when legalized recreational marijuana passed in those locations. What the status is of those bills in Connecticut. The higher THC content of today's marijuana.
not your parents' marijuana.
Linked to different health disorders because of use of, what does it say? Of the amount of drug use, the age of first use, and genetic vulnerability, all shown to influence the relationship. And then, of course, its effect on your physical health, bad for your heart and lungs. The impact it could have on our youth, and various ill effects for school-age children, damage to adolescent brains, on IQ. Okay, somehow the summary is that it's harmless. I guess this is the argument for why we want to do it, you know, in opposition to all the reasons why we wouldn't.
Mhm. That was the final slide.
Okay,
So the notes down there too. Since recreational marijuana was legalized, marijuana-related traffic deaths increased 151%. Versus 35% of all other non-marijuana related. Traffic deaths involving drivers who tested positive for marijuana more than doubled from 55 in 2013 to 138 in 2017. This is all for, you know, a study in Colorado.
Mhm.
The percentage of all Colorado traffic deaths that were marijuana related, it increased from 11.43% to 21.3%. Less consistent with the past. In 2017, less than half of the drivers, 42%, or half of operators, 50%, involved in traffic deaths were tested for drug impairment. 69% of self-identified marijuana users admitted to driving after having consumed marijuana. That was his first. Let me find the other one. Are you seeing something that says legalization of marijuana?
looking at your file folder.
Okay. How about now?
That's it.
But this is, I mean, this is 174 pages or something. So we're not
Okay,
gonna go
so-
through it all, but it's, it will put it up on the, I tried to put it up on the site right before this meeting started, but I don't see it showing up. Maybe it is
So-
for everybody else on the portal, I'm not sure, but anyway, he's provided a long study. Did you email this out to everybody?
Yes, I think.
Yeah, so this was emailed out, both of those documents, we did email it out to the commission ahead of time, we just couldn't put it up as part of the official record. Like I said, just put it up this evening.
To be able to attach it to the minutes though, right?
Yeah, I mean, I don't know why it's not showing up on my portal. You can refresh it, see. Yeah, it's there now, so it's up on the portal right now for people to see.
Okay, so further discussion. Oh, we have someone with their hand raised, Betty Mogul. You can go ahead and speak if you'd like.
Eddie, or if that's Paul, can you unmute to speak? Or press your space bar there?
While they're working on that, maybe we could let someone else speak.
Eric has his hand up.
Yep, go ahead, Eric.
For what it's worth, I recommend that the moratorium be approved and it be approved for 1 year. Thank you.
Thank you. That might be the shortest time I've heard you speak, Eric.
He's practicing for later.
Yeah, saving your airtime.
Madam Chair, I did look earlier, this is Mike Cherry. I looked earlier to see what the statute says as far as the referendum that the community can hold. And it's got to be during a regular general election, which puts it in next November at the earliest. If there's a petition with 10% of the voters by like Labor Day, it says 60 days before. So in support of Mr. Treaster's comment, it looks like 1 year may be more appropriate before we can hear from the public at large by referendum, for what it's worth.
Thank you.
And it can be extended too at the end of 6 months. Same process. So.
Okay.
Madam Chairman, Tom Boudreau. My son is a policeman in another local town, not Ledyard. And he has talked about the increase in problems, traffic crashes, that kind of thing, since marijuana has been legalized in Connecticut. I strongly support the 1 year moratorium.
Thank you, Mr. Boudreau.
Yeah, Madam Chairman, this is, being the former CO of the base, I can tell you that, my issue with the legalization of marijuana is there's no quick test for a person who is under the influence for marijuana. There is a quick test for alcohol. You can do a breathalyzer, but, people do have legal rights when it comes to giving blood for a marijuana test. So it's very difficult to prove under impairment, which is my complaint about it. And until we as a society figure out how to do a quick test for under the influence of marijuana, I would totally agree with a moratorium until we as a society or our town figures out how they're going to determine that. It's the biggest problem for me.
Thank you.
And
Madam Chairman, Tony Capon, I'll go along with everyone else. I'd support a 1 year moratorium for the reason that Mike gave. This may end up being a referendum next November. And we can always shorten it too if we want to, but I think it makes sense to go with a year.
Okay. I agree with all the commissioners, what everyone seems to be in agreement. So is there any other public comment on the issue before we would close the public portion and take a vote?
Hi, just a quick comment for the record. For what it's worth, I'm only one person, but I've personally seen what this type of thing does to many children, many youths, regardless of whether or not it's legal, and even for medicinal. And I've been in places where it is legal, and you get into situations with all sorts of false identifications. And because of the face coverings, because of COVID, people are able to get away with it. And for what it's worth, I just think it's a bad idea. So, in agreement.
Okay. Okay, I think with that, am I supposed to close the public portion of
Close
the
the public
hearing?
hearing.
Okay, so we will close the public hearing and open for commission do we want to have a further discussion or do we have a motion?
I think if somebody, I'll be happy to make the motion if somebody can actually read it, and all we're gonna change in what was read earlier is that instead of 6 months, it's going to go to 1 year. So I will stipulate that I'm making the motion for 1 year instead of 6 months. The staff already has that language in front of them, and I believe they can add it.
And I would second that.
Okay, then I'll just read it for the record. Is it just the second paragraph there?
Yeah, I would just,
Correct.
yeah,
And just read it in with 12 months?
Right, that's the motion I'm making, yes.
Okay, so the motion is that for the Town of Ledyard Planning and Zoning Commission shall not accept or consider any application to permit a cannabis establishment licensed to sell recreational cannabis or medical marijuana as defined by Connecticut Public Act 21-1 for a period of 12 months commencing from the effective date of December 1st,
January.
2021.
it'll have to be, what did we decide that the effective date was gonna be? It's the day after publication, so. So you can say commencing from, I think it's-
January.
Yeah, just, oh God, we did it out December 15th, right?
So it becomes published next week.
Yeah,
Effective the
I-
day after publication, you could say.
Okay, effective the day after publication. I don't think I need to read the reason, do I? That's our motion.
Correct.
So I will call a vote. Tony,
Yes,
Paul,
Yes,
Tom,
Yes,
and myself, yes. Okay. Passes unanimous. We can move on to the next public hearing item. Application PZ 21-14 RA of Eric Treaster, 10 Huntington Way, Ledyard, Connecticut, to amend the zoning regulations to permit hosted short-term rental as an accessory use in residential districts.
Thank you.
Which do you want up first, Eric?
I think it's Exhibit 11 is the one I sent you. I think I actually sent it to you twice, but I sent it to you late this afternoon.
This one?
It's titled Reasons Why Short-Term Rentals Should Be Regulated by Zoning and Reasons Why Non-Hosted Short-Term Rentals Should Not Be Allowed.
Right.
Okay. First, I want to thank you for holding this hearing. My name is Eric Treaster, and I'm representing myself this evening. As you know, Section 8-11 of the Connecticut General Statutes provides that no member of a zoning commission shall participate in the hearing or decision of the commission of which he is a member upon any matter in which he is directly or indirectly interested in a personal sense. The purpose of this statute, in the interest of fundamental fairness, is to prevent the appearance of predisposition or predetermination. I respectfully request that anyone on the commission who has a financial interest in short-term rentals to disqualify and recuse themselves from hearing this application. My presentation will cover 5 areas. The first will identify concerns and problems residents have regarding short-term rentals in their neighborhoods. The second will explain why a short-term rental is a commercial and not a residential use of property. The third will explain why in residential districts, hosted short-term rentals should be allowed and non-hosted short-term rentals should be prohibited. The fourth will be a brief discussion on the proposed text changes to the regulations. And the fifth and last will address the enforcement of short-term rental regulations. It is important that everyone has the same definitions of terms used in this presentation. I define an STR as an accessory use of a furnished single-family dwelling consisting of the rental of one or more of its rooms to one or more guests, where the rental term is 30 days or less, and the rental is subject to the Connecticut room occupancy tax. An STR is defined as an accessory use, which means the single-family dwelling must have a principal use. That principal use is the legal residence or the domicile of its owner, who would be the STR host. A hosted short-term rental is defined as a single-family dwelling with an STR host. As such, an STR is exactly the same as a hosted STR. I define the term host as the owner operator of a short-term rental domiciled in a single-family dwelling used as an STR, who is responsible for its operation. An apartment, as defined in section 2.2, can be a dwelling in a single-family dwelling. These are often called in-law apartments or accessory apartments. My proposed regulations allow the owner of the home to reside in the accessory apartment and to use the remainder of the home as an STR. However, the proposed regulations do not permit the accessory apartment to be used as an STR. The reason is because one of the purposes of allowing STRs is to permit a homeowner to earn enough money from the rental of the unused rooms in his home to pay for the home's maintenance and taxes so he can remain in his home. The homeowner can always rent his an accessory apartment or the balance of his home under a long-term rental agreement. The term non-hosted STR is not in the definitions because the phrase is not used in the proposed regulations. This is because a non-hosted STR would be a principal use of a home, and both our current zoning regulations and my proposed regulations do not permit STRs as a principal use. The Town Council's STR ordinance, which expires on February 27th, allows both hosted and non-hosted STRs. Okay, at this time, I'd like to put up Exhibit 8.
All right, bear with me here.
Let me know when it's up so I don't have to uncover it here.
I have lost our agenda, which is the problem here.
This is a list of representative STR problems and complaints over the past 2 years.
Hang on. That one?
Yes. Yeah, this Exhibit 8 is a list of representative STR problems and complaints over the past 2 years. It is not a complete list because it does not include police reports and it does not include verbal complaints. But what is interesting is that all of the STR problems in Exhibit 8 originated from non-hosted STRs. I suspect many of you, as guests, have had positive experiences using short-term rentals. However, I am asking that you think differently this evening. I am asking you to consider non-hosted short-term rentals from the viewpoint of being a neighbor. The unsolvable problem is that it is impossible for the owner of a non-hosted STR to pre-screen their guests. This is also true for a hosted STR. However, it is unlikely that guests who intend to create a party house weekend nuisance will rent from a hosted STR and instead will rent a non-hosted STR. As a result, it is far more likely that a non-hosted STR, which could have 2 to 16 or more unvetted strangers move into a vacant short-term rental house each weekend, will not follow the rules. There is no way for the host to know if his guests are dangerous, if they have a criminal record, if they have pit bulls or Dobermans, if they are on the sex offenders list, if they constitute a risk to children, if they are drug dealers, if their cars are insured, if they will create a party house that disturbs the peace and quiet, or if they are likely to invite dozens of additional people into the home. The reason I submitted this application is I believe no neighbor of an STR in a residential district should be required to tolerate this risk. I also submitted the application because I do not want short-term rentals to harm Ledyard's reputation as a desirable place to raise a family. Even if infrequent, disturbances caused by commercial, non-hosted, short-term rentals are heartbreaking and should not be allowed to happen. I also submitted the application because I believe that unless our short-term rental problems are solved, it is only a matter of time before a group of neighbors harmed by a short-term rental will submit coordinated applications to the Board of Assessment Appeals to reduce the value of their homes, and it will be difficult for the board to deny such appeals. I know that personally, I would never rent or purchase a home for my family if it was near a non-hosted short-term rental. I also do not want non-hosted short-term rentals to increase housing costs by reducing the availability of homes for permanent residences, which is in conflict with the housing sections of the POCD. And I do not want non-hosted STRs to take business away from our Two Trees Hotel, our Abbey's Lantern Hill Inn, our Stonecroft Country Inn, and our Mayor's Bed and Breakfast Inn, which are taxed as commercial business properties and not as single-family dwellings. Non-hosted short-term rentals are a commercial use that, if allowed, should be limited to commercial districts. Okay, now we want to put up Exhibit 4, please. And this is a copy of a newspaper article from the day for why NOANC chose to prohibit both hosted and non-hosted short-term rentals.
Are you seeing it on the screen?
Yes.
Yes, thank you. NOANC's zoning regulations, like ours, do not address short-term rentals. And if a use is not listed, it is prohibited. If you wish to prohibit all STRs, you can do so by not adopting my proposed regulations. And when the council's STR ordinance expires on February 27th, you begin enforcing the current zoning regulations. However, I recommend adopting the proposed STR zoning regulations to allow regulated, hosted short-term rentals, which have no history of creating neighborhood problems. Several owners of short-term rentals said they understand and sympathize with the concerns expressed by the neighbors. Their owners claim they are our friends and neighbors and have no interest in destroying the character of our neighborhoods. They have said they want the town to not ban short-term rentals, but instead to regulate them. In response, the town council adopted ordinance 300-30 on February 27th of 2000 to allow and regulate commercial, hosted, and non-hosted short-term rentals in residential districts. However, as shown in Exhibit 8, the ordinance failed to prevent short-term rentals from creating neighborhood nuisances. We can put
Exhibit 8 up on the screen.
8?
Yeah, 8.
No, that's suggestion. I'm sorry. What we want is I think what we want is over 7, Exhibit 7.
That's the ordinance compliance.
Yes, that's the one. That's the one we want. Thank you. As shown in Exhibit 7, over half of the short-term rentals advertised on Airbnb on December 2nd for Ledyard do not even have the permit required by the ordinance. As such, it is unlikely that strengthening and extending the council's STR ordinance will solve the problem, especially considering that the underlying unsolvable problem is that it is impossible for an STR owner to pre-screen his guests, which means he cannot assure the neighbors that they will not be disturbed. There are 2 reasons why short-term rentals are technically a commercial use and not a residential use. The first is because Connecticut charges short-term rental guests a 15% daily commercial occupancy tax, which is the same as Connecticut taxes guests staying for 30 or fewer days in hotels and motels, B&Bs, and country inns. The second is because guests in short-term rentals are subject to Connecticut's innkeeping statutes, which means a guest in a short-term rental is not protected by the tenant-landlord laws. An STR host, who would also be an innkeeper, can lawfully eject his guest for any reasonable reason, including if a guest is visibly intoxicated, under the influence of drugs, disorderly, creating a public nuisance, is using a short-term rental for an unlawful purpose, or is creating a danger to other persons, including brandishing firearms or threatening the use of explosives. The owner or the innkeeper of a short-term rental can also immediately eject a guest who is in violation of any federal, state, or local law, or if he is in violation of the house rules. With all this power, How is it possible for short-term rentals to create problems in our residential neighborhoods? The answer is because the owner of a non-hosted short-term rental does not know his guests are creating a problem until a neighbor complains or the police are called. By then, it is too late, except to say sorry. Admittedly, problems created by a non-hosted short-term rental are infrequent. However, they happen, and it is fundamentally unfair for neighbors to worry if they are in danger, or if they may be disturbed, or if they will have difficulty selling their homes simply because they live near a short-term rental. Section 1.2a in our zoning regulations states that the purpose of our regulations is to promote the health, safety, and general welfare of the community, to conserve the value of property, and most importantly, to encourage the most appropriate use of land throughout the town. As a land use, the zoning commission, not the council, is the entity statutorily responsible for regulating where short-term rentals should and should not be located. As mentioned earlier, our current zoning regulations, consistent with its statutory purpose, prohibit hosted and non-hosted short-term rentals in residential districts. Non-hosted short-term rentals are prohibited because they are not listed as a principal use in the Section 3 use table, and because Section 3.5A4 in our zoning regulations state that, quote, any use not listed or otherwise permitted in a district is prohibited, unquote. Hosted short-term rentals are prohibited. Hosted short-term rentals are prohibited because they are not a customarily incidental and subordinate use to a listed principal use. Our regulations allow some commercial uses in residential districts. For example, they allow low-intensity, virtually invisible home occupations, low-intensity B&Bs if on 5 or more acres, and medium-intensity country inns if on 6 or more acres. My proposed regulations treat hosted short-term rentals much like our current regulations treat hosted B&Bs and hosted country inns. These low and medium-intensity commercial uses in residential uses share a common feature. Each requires its owner to reside on the property and to manage the business. Home occupations, B&Bs, and country inns, for practical purposes, have no history of affecting the quality of life of their neighbors or of reducing the desirability and values of nearby homes. Hosted short-term rentals also have no history of affecting the quality of life of their neighbors or reducing the desirability of nearby homes. There are 4 reasons why hosted short-term rentals should be acceptable in residential districts. The most important is because, with the owner of the home residing on his property, potential guests who intend to turn a home into a weekend party house are unlikely to rent rooms in his home, but instead will choose to rent a house that does not have a resident host. The second reason is that if guests do begin to create a problem, the resident host will know immediately and can quickly intervene to maintain order before the neighbors are disturbed. The third reason is that a resident homeowner should have the right to earn income from his unused rooms to help pay for the maintenance and taxes on his home. The fourth reason is that a hosted short-term rental is a use that does not reduce the number of homes available for permanent residency. Some people may believe that instead of adopting and enforcing zoning regulations for short-term rentals, it would be better to improve and enforce the short-term rental ordinance. There are several problems with this approach. The first reason is parking. I believe a short-term rental, if allowed, must be invisible or nearly invisible in a neighborhood, which means there must be a prohibition against on-street parking in the regulations. If enforced under an ordinance, no parking signs would have to be posted in the neighborhood, and the no parking signs would differentiate the short-term rental from other homes in the neighborhood. In addition, under an ordinance, the owner of the short-term rental can argue that failure to comply with the no on-street parking requirement is the responsibility of his guest, not him, and he would be correct. However, if parking is regulated under the zoning regulations, there is no need for no parking signs because the property owner is always responsible for compliance with the applicable zoning regulations. It should also be noted that a Google search shows that short-term rentals are typically regulated or prohibited by zoning. For example, Canton, Hartford, Newington, and Noank regulate short-term rentals under zoning. Nationwide, about half of short-term rental regulation is under zoning and half under town ordinances. This is important because zoning has over a 100-year history of limiting individual property rights for the greater good. This fact makes it difficult to argue that the proposed zoning regulations to prohibit commercial, non-hosted, short-term rentals in residential districts would constitute an unlawful taking. Perhaps the most important reasons are that if STRs are regulated by ordinance, enforcement is by the police, and enforcement happens only after a problem occurs, which is too late for the neighbors who have been disturbed. In addition, violation of a town ordinance is a civil matter, which will be time-consuming and expensive for the town if challenged in court. Regulation by ordinance also creates the question of what constitutes a violation. For example, should a vacant STR with unsafe water or a failed septic system be fined daily or weekly, or must it be advertised or occupied to be subject to a daily fine? Should an STR be fined only for the days its guests create nuisance, or for each day its advertising fails to mention that its guests are not allowed to create a nuisance? If an Airbnb STR ad fails to show that parking is limited to 1 vehicle per bedroom, should a daily fine be imposed or its permit revoked? How many times must an STR with an expired permit advertise its availability before a daily fine is imposed? Or must an STR with an expired permit be required to have a guest before a daily fine is imposed? And how will the town know if it has or does not have guests? In my opinion, the ordinance and citation enforcement mechanism is too subjective, too easy to abuse, too cumbersome, and may not hold up in court. Citations are also fundamentally unfair because many STR violations will be outside the control of the STR owner. I also do not want to see a situation where a fine is not paid and the town is forced to place a lien on the property with the result that the violation continues for months or perhaps years. In my opinion, the citation mechanism will not be an effective tool for enforcement. In addition, if there is litigation, it will be a civil matter and the town will have to pay its share of the legal cost. However, there are important reasons why short-term rentals should be regulated under zoning. First, zoning allows the town to consider a special permit, and a special permit allows the commission to consider a wide range of subject areas and to have discretion on how it evaluates subjective requirements. For example, the commission could deny a short-term rental special permit application because of inadequate sightlines, even if sightline requirements are not in the regulations. Other examples include if an applicant's proposed house rules and policies are inadequate, or if a short-term rental use will stand out in the neighborhood. A special permit also gives the neighbors an opportunity to express their concerns and the commission the opportunity to address those concerns by imposing conditions of approval. These tools are not available if short-term rentals are regulated by ordinance. But the most important reason why short-term rental regulations should be enforced by zoning is that if necessary, under CGS section 8-12, the zoning enforcement officer can issue cease and desist orders. And this is time for Exhibit 3 to be put up. Exhibit 3 is a copy of Connecticut General Statutes 8-12. The law is clear that ignoring a cease and desist order for more than 10 days can lead up to a $2,500 fine, and more importantly, up to 30 days of imprisonment. These remedies are not available in civil enforcement actions to enforce town ordinances. Under section 15.4B1 of the zoning regulations, the recipient of a cease and desist order has 15 days to appeal to the Zoning Board of Appeals. Admittedly, the cease and desist order is stayed until the ZBA renders a decision, unless the ZEO certifies that the violation constitutes an imminent parallel to life or property. However, it is rare for a cease and desist order to be appealed, and the ZBA meets monthly. The zoning enforcement officer contacts the state's attorney or the housing prosecutor for New London County if it is necessary to seek criminal prosecution. One of the benefits of issuing a cease and desist order is that if there is litigation, the state pays for it, not the town. In the real world, cease and desist orders are not ignored. One of the questions you may have is how will the ZEO find the locations and identify unlawful short-term rentals when he looks at the Airbnb website? The answer is that the Airbnb website, while it does not specify exact addresses or the full names of its owners, it does show the area within a few hundred feet of where the STR is located. In addition, the ad's text description often uses the phrase entire house for a non-hosted STR, plus a photograph of the home and enough information to learn where the STR is located. In Ledyard, where almost every home is unique, it will not be difficult to determine which homes are being marketed as non-hosted short-term rentals. In addition, Airbnb ads list the number of bedrooms and the maximum number of guests. If the number of guests exceed 2 per bedroom, or if the ad states the entire house is available, or fails to disclose that the host lives on the property, then that STR will be in violation of the STR regulations. Exhibit 7, which identifies the STRs that do not have permits or are in non-compliance with the STR ordinance, was prepared using easily obtainable information from the Airbnb website. Okay, I will now go through the proposed regulations. Please look at page 4 of Exhibit 1. The council's short-term rental ordinance defines a short-term rental as a rental for 21 or fewer days. My proposed definition changed this to 30 or fewer days to be consistent with the Connecticut Hotels Occupancy Tax provisions and the Connecticut Tenant Landlord laws. Note that I do not define non-hosted STRs. This is because the term is not used in the proposed regulations. Does anyone have any questions, suggestions, or concerns regarding the proposed definitions? Item 2, which is on the same page, is the proposed change to the Section 3 use table. I am proposing a change that will allow hosted STRs by special permit in R20, R40, and R60 districts. The reason STRs in commercial districts are not addressed is because I am primarily concerned about protecting our residential districts. Note that the phrase accessory use is unnecessary in the use table because the definition in Section 2.2 states that an STR is an accessory use.
Eric,
Yes.
I would just point out that even though you say it's allowed by special permit in the residential zones, if there's an existing house in a commercial zone, you would have to allow them to have one too.
Okay, thank you.
Because they get to enjoy what other
Yeah,
single-family residences have.
Yeah, I agree with you that we should expand the special permit to include single-family dwellings in the commercial districts. And but again, I only had a limited amount of time to prepare this. So the Section 8.28 are the supplemental regulations for STRs. The proposed Section 828-1 is the purpose of the proposed STR regulations, which is, quote, to permit the accessory use of a furnished single-family dwelling in a residential district as a short-term vacation rental for financial gain in a manner that protects public health, safety, convenience, and present and future neighboring property values. Section 8.28-2 lists the requirements that must be satisfied to operate an STR. I am not proposing an annual fee or license requirement. This is because the current zoning regulations do not impose annual fees or licensing requirements to conduct home occupations, B&B businesses, or country inns. And I believe hosted STR should be treated in a similar manner. You can, of course, amend the fee structure as a routine agenda item if you believe hosted STR should be subject to renewal fees or to renewal licenses. The most important requirement is 8.28-2 at the bottom of page 4. This requires the homeowner to be the host and domiciled in the home that will be used as an STR. This means that if a home is owned by a limited liability company, a corporation, or a trust, it cannot be used as an STR. This is consistent with the policy that a resident hosted short-term rental in a residential district is not intended to be commercially profitable, but is only intended to allow the homeowner to have a financial gain to help offset his maintenance costs and taxes so he can afford to continue to reside in his home. The proposed section 8.28.3 is in the middle of page 5. It lists the minimum content requirements for the STR host-guest agreement. The host-guest agreement is similar to a lease because it establishes the identification, rights, and responsibilities of the host and his guests during the term of occupancy. The proposed section 3-3 at the bottom of page 5 lists the breeds of dogs not allowed in an STR. These particular breeds are dangerous, especially if not well trained, and they tend to intimidate the neighbors. I believe no one should have the right to intimidate their neighbors. Note that there's an exception in section 3.3 if a guest has a pit bull or Rottweiler or one of the other prohibited breeds, if the dog is an emotional support animal under the Americans with Disability Act. I recommend a minor change to the application that the host-guest agreement include a disclosure that states, quote, the host will reside in the home during the term of this agreement. This should be added as item 3-17. The addition would be a minor change and it would not require an extension of the public hearing. The proposed section 8.28.4, which begins at the bottom of page 6, is a requirement for an applicant for an STR special permit to include certain subject areas in his proposed house rules and policies. One of your questions might be, what happens if a special permit is granted and the owner of the STR wants to amend his house rules and policies? The answer is that the owner of the STR would submit an application for a minor change to a special permit, which is allowed under 3.5A-3-3 in our regulations. Minor changes are defined in section 2.2 of our regulations. And if the changes are to the conditions of a special permit, the commission addresses them as an ordinary agenda item. There would be no cost and the proposed amendment would not require a public hearing. The proposed section 8.28.5, which is in the middle of page 7, specifies what must be addressed in the advertising for the STR. The STR advertising must disclose, for example, the maximum permitted occupancy, parking constraints, pet rules, and a prohibition on creating nuisances. I recommend a minor addition, which is to add a disclosure stating that the home is the residence of the host. This would also be a change that would not require an extension of the hearing. Section 6, beginning in the middle of page 7, are the application materials that must be provided for a special permit for a hosted STR. Section 6-9 is the requirement for a report from a licensed on-site wastewater specialist if the STR is not on a public sewer system. However, I recommend this requirement be deleted. A septic system either works or does not work, and if it does not work, it automatically becomes the responsibility of the homeowner. The deletion of section 6-9 would be a minor change that would not require an extension of this hearing. Section 6 requires reports from the fire marshal, building official, zoning official, and the health district inspector, but does not specify what is required in those reports. This is intentional. The inspectors know what they are doing, and there is no need to regulate hosted STRs more stringently than B&Bs or country inns. Section 828.7 at the top of page 8 lists the standards for granting a special permit for a hosted STR. The first 4 standards require subjective evaluations, which are appropriate for uses that require a special permit. The last 2 standards, that the applicant is current on his taxes and there are no existing zoning, building, health, blight, fire, or other violations, require only an objective evaluation. The last are the proposed section 10 parking requirements for an STR. It requires that the parking for an STR must be such that no parked vehicle blocks the entry or exit of another vehicle. It also requires the parking be off-street and paved for both the STR owner and the STR guests. I suggest this requirement be relaxed to allow the off-street parking to be on gravel, crushed stone, or on pavement. Allowing parking on gravel or crushed stone in addition to on pavement would be a minor change to the application, which would not require an extension of the hearing. This completes my presentation, and I will be happy to respond to any concerns, questions, or suggestions regarding the application. I do, however, reserve the opportunity to address the commission after members of the public speak, or if you intend to solicit a legal opinion of the proposed regulations. Thank you.
Thank you, Eric. I should state that due to a minor mistake with the timing of this application, that we are accepting this and we are opening it for comments, but we are going to table it and any discussion for next month. Okay. So
Yeah, that'll be good. Thank you.
okay.
And I'd like to suggest that if people have suggestions, that they get them into staff quickly, and that way they can be incorporated in a timely manner to satisfy the 10-day posting requirement in the clerk's office, so that they can be discussed when the public hearing continues. Thank you.
However, if there are public here that did come to make a comment because it was listed as a public hearing, you have to let them speak.
Yes, I would like everyone who would like to speak on this to do so at this time.
Dave has a hand up.
Yeah, I'd like to say, since the first weekend in April, our next door neighbor, 28 Pumpkin Hill Road has.
Oh, sorry.
What's
Can you
your
state your
name?
name, please?
Oh, I'm sorry, David Muollo, M-U-O-L-O. I reside at 430 Pumpkin Hill Road, and our neighbor at 428 Pumpkin Hill Road has been renting out his property as an unhosted Airbnb since April. Every weekend, except with the exception of one weekend that I recall, he has been renting it out to it's unhosted, and on most, except for a couple of rare exceptions, on most occasions, it was a bunch of people who are not related. It's not a single family. There are multiple adults, and there's been, and many of the weekends I've counted as many as 15 cars. One weekend I counted 9 cars on Thanksgiving overnight, and it's just been an ongoing violation after violation in a place that he never had a permit to start with. He knows he should have had one, and he's continuing to rent it. And it'll rent again this weekend, and there's no way that the town can stop him except to say we're not giving you a permit. And he says, okay, I'm continuing to rent it without a permit, and he'll continue to do so until. That's why I'm in favor with what Eric's talking about, because then they'll have some teeth to it where they can go and tell. And they can tell Chad Novak that you cannot rent this place unless you get a special permit and you are a resident at the house. It's just his second house that he owns in Ledyard. And this way it'll put a stop to us having to worry about these. I mean, in many weekends, there have been parties that have been noisy until 2:30 in the morning. And I find that Eric's proposal here would give the town a way to stop this from being a neighborhood nuisance. And I know other neighbors besides myself have also filed complaints with the town. So I'm in favor of what Eric is proposing.
Thank you. Yes, Jim.
Yes, Jim Harwood, 10 Eska Drive. I'd like to make an amendment to what Eric just presented for his exhibit number 7. He has the property, the illegal bed and breakfast property at 6 Eska Drive listed as 5 bedrooms, but it's actually a 3-bedroom house. If you look it up in the property, it's a 3-bedroom house. So when he says he can have 10 guests, that's not the case. He could have 6. That's all I have.
Same thing at 28 Pumpkin Hill. He's doing the same thing. It's a 3-bedroom house, and he says it will host 10 adults, and that's against Airbnb's regulations also.
I believe the person on the phone wanted to speak.
Hello.
Hello.
Hi. I'm hoping I can speak as well.
Yes, please state your name.
Sure. My name is Pam Bartlett. I would like to first thank everyone on the commission for hearing Mr. Treaster tonight, and I really can't express how grateful I am to that man for just how much effort and time and energy he has spent. He's just an asset to the town of Ledyard, truly, to put so much effort and research into this issue. I personally am one of those people who made complaints. I live in the neighborhood. I was a casual Airbnb user myself in the past until I lived next to one and then multiple in my neighborhood. I had no idea truly how out of hand and what the magnitude of the problem really was until I experienced it firsthand. So I appreciate that he asked all of you to look at this as a neighbor as opposed to perhaps the person running the Airbnb or short-term rental. Basically, I feel like what he's proposing is fair. It protects homeowners. It protects the town. It even actually protects the owner of the short-term rental, be it corporate or however this is happening right now. I feel like this is just a way to hopefully protect and preserve our small town and the quality of life for people living in single-family residential neighborhoods. I've been ripping my hair out. This is the first time in years, honestly, in years, that I feel like there may be a solution to this problem that I, as a homeowner, can live with and I can understand, and that just seems fair and reasonable. And I truly hope it will be adopted and amended. I'm worried otherwise, really, what is going to become of Ledyard, just like every small town in Connecticut and beyond, if our neighborhoods become corporately owned, unoccupied, short-term rental businesses. There's going to be no community. There's going to be no neighborhoods anymore. There aren't going to be homes available for families that want to live in a community, in a neighborhood. So this really feels like it's crucial. We're in a time where I understand the world is changing fast, and Airbnbs, I don't think this was the intention at all of what that company even meant to be. It was meant to be hosted in small villages where there weren't enough rooms for people to visit a unique place and learn about the historical value of a place, and also meet people who live there and be almost a part of the community for their visit. That's not what it is today. It's turned into a profit engine, and it's just destroying, it's eroding neighborhoods and communities. So I'm strongly in agreement. I support this amendment. It just sounds like really a viable solution for everybody. I hope it'll be considered very strongly. And my husband is also here. I don't know if he would be able to speak as well. Thank you.
Thank you.
Hello, my name is Gino Cozzolino. I'm Pamela's husband. I had many things to say, and I have now nothing to say other than I support Mr. Treaster's proposal. Exceptional, thorough, just remarkable, and I appreciate his effort. That's all I have to say.
Sir, would you mind spelling your last name or your full name?
My name is Gino, Gino. My last name is Cozzolino.
Thank you. We're way off.
Thank you for speaking. Do we
No
have
other- If no other public, when public is finished, I wanted to say something as well. But I'll wait.
Hi, Jim Arek, another chime in. So I read Mr. Treaster's extremely detailed presentation and all the exhibits, and I'm just amazed that this type of problem has carried on for so long. And I'm not sure if Mr. Mike Cherry knows the answer or not, but I noticed in the exhibits that there were some occasions where Mr. Cherry had given multiple notices of violation to the people that were having non-hosted STRs. And I was just curious as to whether or not there were a certain amount of violations before they could start getting fined. And then also, if it turns out to be big corporations, perhaps an idea might be larger fines for corporations as opposed to proprietors. Thanks.
If I could, Katie. it's Mike
Yes,
Cherry.
please.
The problem today, Jim, and for other members, is if you read the short-term rental ordinance, there are no fines. The penalty is if you violate the ordinance, we will void your permit. So if you're operating without a permit, it immediately runs into a legal issue where the only option the town has is to exercise its authority under 7-148 and call the lawyer to go take legal action against them, and that's on our nickel. So we're working on getting a couple of strong letters from lawyers, but the ordinance did not envision people operating without a permit.
Okay, understood. Thanks.
May I speak?
Of course.
So Juliette Hodge, the planning director. So I did attend the town council administration. I'm sorry, I don't know the names of the committees, but that meeting last night. I do agree with Eric 100% that it should be in zoning. It's just a more effective, tried and true way to regulate land use and control certain aspects about that use. Like I explained in the meeting yesterday, that ordinance sort of tries to be one size fits all, and it does sort of assume that you're going to get the permit to begin with, which we all know a lot of problems in land use are people doing things without a permit. I mean, that's so common. So this issue isn't one size fits all. I do think Eric's regulations go a little bit farther than they need to be. I mean, I think that there are, very specific things that we can address, such as the noise, the maximum occupancy, buffering, many things. And I have actually written up some regulations too that I'm going to submit for you to consider. And one other thing that came up in the meeting last night was I guess there are some permitted B&Bs that exist right now where the host is living in the house at the time that the guests are there and they haven't had any problems. So we were thinking, well, we don't want to punish them necessarily. So in the regulations that I wrote up as well, I sort of give some definitions, the general condition or general criteria, but then I give an out for a hosted Airbnb where the resident is there with the guests at the time that they're there in the house, that they didn't have to comply with some of the stricter requirements, like a minimum acreage, for example. So there's some tools like that. Like if you did pick a minimum lot size, you would eliminate the problem of Airbnb in small, dense neighborhoods right off the bat. Or if you required a certain amount of off-street parking, then you would eliminate the possibility of an Airbnb around the lakes, where there are no off-street parking, or there's very few off-street parking spots. And if they have to reserve a spot for the host themselves, then they would never meet that criteria. So we're trying to anticipate where are the problem areas most likely, and that would be on areas where the lots are smaller or houses are closer together. And so you can come up with regulations that can control that much easier in a zoning regulation than you can in an ordinance. And I was trying to figure out, at one point, somebody said that they had picked the ordinance because they thought it was more nimble, and I don't understand that, but zoning regs can be changed all the time. I mean, if something about this regulation didn't work, you needed to add something, we come back and we tweak it. So I will, I'm going to submit, I'll show you what I'm going to submit, but then I'll just, give it to you and you can look at it some other time. But is that up there now?
Yep.
So just, I tried to keep a lot of Eric's wording as well. And, talking about owner occupied, that can't be in a multifamily apartment, obviously, regardless if the owner is there. They can't be subletted. I did like the idea of those the guest host agreement, you know, all the things that were on there. The detailed floor plan is important. And one other thing that I think Eric started to get at with Ledyard, I would say in here that for the purpose of this regulation, a application for a short-term rental constitutes a change of use, which automatically involves Ledyard, you know, to look at it, to make sure that the septic system is okay and all that. Also non-lodging uses for guests, not necessarily the owner that lives there. If the owner's son is getting married or something, of course they could have a wedding at their house, fine. But the idea is that for guests, so it didn't happen every weekend, they can't have any of the parties and whatnot. And then I was just adding in some parking, quiet time. You could regulate something like outdoor amplified music. And as long as we have all of these types of criteria listed, and I am working on your regular regs to make sure you have plenty of site development standards and special permit criteria that you could also latch onto if these were required by a special permit. You have a lot of tools in zoning to control this problem. You don't have those tools in an ordinance. And Mike Cherry is also correct. In zoning, there's a path through the system that, you know, it still takes a long time sometimes to get your fines or your legal costs recovered, but you can recover them. Whereas if it's a civil matter, we're not, we would lose all that. So if you get to the point that you're in the courts and the judge finally rules in your favor, we can recover, the town can recover their legal fees as well as the fines that are levied. So that's one big bonus for doing it in zoning. But I was suggesting, you know, notice of violation on the first offense, cease and desist right on the second, boom. Third offense, revoke the special permit. So I'll leave this, you know, I'm going to enter it in somehow, I guess, on the portal and email it out to the commission members, just as something, an alternate to think about as well. And I'll stop there.
I'd like to respond a little bit for that. Would that be okay?
Sure.
Juliet has done a tremendous job doing two things. She does an excellent job reviewing my work, and she tolerates me, which is amazing. So anyhow, I really appreciate her contribution. One of the reasons I hustled so hard to get this in as quickly as possible is because the ordinance expires on February 27th. And I don't want the situation of nothing being in place on February 28th. So one thing that we could do is incorporate Juliet's recommendations into my version. It doesn't have to be perfect. Approve it so we have something in place on February 28th that works. And then as part of the effort to update our zoning regulations in their entirety, that effort will include fine tuning the section 828 for STR regulations. So it's just a thought, but I think it's really, really important. And I've worked my tail end off to be able to have something that will work, that can become effective on February 28th, the day after the STR ordinance expires. Thank you.
Thank you,
Katie,
Eric.
if I could ask a really quick follow-on question to the question that was just asked of Mike Cherry. So
Sure, this is Jim.
Jim Harwood, yes.
Okay.
So Mike, yesterday I proposed a question. It didn't really have an answer at the administration meeting. But so one thing I'm confused about is I understand that if a permit's been issued, then they're subject to the ordinance. But if somebody's operating without a permit, then does the ordinance not apply? And then that really should even now go back to zoning to prosecute that person for not having a permit? I don't understand why the ordinance applies to that situation if they've never applied for a permit.
The ordinance applies. The ordinance just doesn't have any penalties. When you read the part on enforcement, it doesn't give any tools to the enforcement agent. It says I think the words are like civil action may be taken. I don't have it in front of me.
But if they haven't filled out an application, Mike, then they're not really subject to the ordinance's requirements, but they're still subject to the zoning requirements. Or am I incorrect in that assumption?
I believe you to be incorrect. That everybody in town subject to zoning. And if you're running a short-term rental, ordinance 300-30 applies. Whether you got the permit or not, the ordinance still applies. What's missing is an effective enforcement tool for whoever you want to designate as the enforcement official. And I applaud Mr. Treaster and maybe some other staff for taking time, matching pictures and areas on Airbnb and VRBO saying, oh, that must be this house. But to be quite honest, the town is in dire need of a full-time enforcement official for wetlands, zoning, blight, short-term rentals. I volunteered to fill in at 15 hours a week, and I'll tell you, 15 hours a week is less than half the time required to do the job that our residents would like, especially those that are stuck living next door to things that are untenable. So if you know somebody that is in their mid-career instead of well past their second career, that has an interest in land use and some background, Juliet would sorely like to talk to them.
Thanks, Mike.
And I would ask, why we're taking some time over the next month to look at Eric's proposal and Juliet's counter proposal. Take a look. I see Erica Hall is on the call. Take a look at what our regulations say for country inns and bed and breakfasts. Are we treating an Airbnb more favorably or less favorably? Are we imposing things on our country inns and bed and breakfasts that are professionally managed and run commercial activities that we're not going to impose on the guy that lives next door to Jim? And decide in your mind as a zoning commissioner, is that fair or isn't it? But you ought to look at those regs too. They've been there for a while.
And I'll also say, as a reminder, that the reason we went with the ordinance originally was because that was based on the legal advice that we received at the time, which was that regulating short-term rentals via zoning was discouraged by that council, citing various other local examples and litigation. So,
And I told the council commission that I would try to seek out another opinion as well.
okay.
So if we have any more things to say about short-term rentals or whatever, where do we send our emails?
To me,
To
to planner@ledyardct.org.
Oh, planner? Okay, planner is, okay. Okay, thank you.
Yep, anything written in can be submitted to the record so it can become part of the continued public hearing.
Right.
And I think if the commission agrees, I think we should table our discussion until next month when we can have a chance to read both Eric and Juliet's proposals together and when we've received public comment. Yes, Eric.
By tabling and continuing the public hearing, which I think is an excellent idea, it gives an opportunity for not just minor changes, but it also gives an opportunity for major changes to be incorporated into my application. And as long as they're posted 10 days in the clerk's office, we do not have to re-advertise or do anything else. It's part of this application. I don't want to have things extended so that we end up with the impossibility of having something in effect on February 28th when the SDR ordinance expires. So, and like I said before, I do not object if Juliet or anyone else makes substantive changes to my application, and they can be extensive. I don't object to that. My goal is to have something in place that will work on February 28th. And by tabling and continuing, those changes can be provided to Juliet and posted and discussed during the public hearing and eventually voted upon. And still make it by February 28th. It will be a disaster if we come up on February 28th and the ordinance has expired and there's nothing in zoning except total prohibition, which is what will happen if nothing is done. Thank you.
All right, thank you. If there's a comment in the chat, should I read it into the record?
You can, and we've made a note of it, but read it out loud just in case it doesn't show up somehow in the
I've
cloud
received
recording.
them too, yeah.
Okay, so this is from Erica Hall, and she says, I'm 100% in favor of this zoning rule. It levels the playing field and promotes the safety of Ledyard residents. I know firsthand that not all guests are safe and not all STR renters are honest in their stated intentions for renting a property.
I received a chat also, which I'd like to read into the record. And it suggests adding a minimum of a $1 million liability insurance as required in order to operate a hosted STR. Something to discuss. My proposed regulations require insurance for STR, but I don't think it specified a minimum threshold amount.
Okay, we can look into that. If there's no further public comment at this time, I think we would like to table this discussion and continue the public hearing to next month. So without objection, I think we will do that at this time.
We need to specify a day and a location on the record.
Okay. Until our next public hearing.
So your next
Juliet,
regular meeting.
our next regular meeting.
Yep.
Which I believe is January 12th.
Yeah, the second January is January 13th. I mean, the second Thursday is January 13th.
Okay, right.
At 7 p.m. All right. Thank you, Eric. I think we will move on to the next public hearing, which is application PZ 2110 Resub Fireside Farm 4-lot resubdivision, 34 Village Drive, M-53, B 2534 and L34. Owner Anthony Silvestri and 16 Reuven Drive, Ledyard, Connecticut. Oh, those are the map and lot numbers. Owners Mario Luis Mendez and Susan Ponta, applicant James Bernardo, land surveying. Zone R40, 12.42 acres. This was received 8/10/21, and it was continued until November and December, and now continued to today.
And there's one new exhibit that was received, and that's exhibit 29, driveway exhibit, which was submitted today.
Okay. So because of those continuations, I believe we have to close it today unless they offer an extension. Is that correct?
Definitely have to close it today, and we'd have to figure out how many. I'd have to do some math to see if they were entitled to another extension.
Okay. So now we have our inland wetlands decision. Is that correct?
Yes, we did receive that on this the 7th. It's not up on the record, but there it is. But they did recommend a favorable report.
Okay.
And Jim is here tonight.
Okay, so would Jim like to speak?
Okay, let's see. Can you see me?
We see you.
Okay. I can see you. I wish I could see myself, but anyway, I can see you. My name is Jim Bernardo. My address is 102A Spithead Road in Waterford. I'm representing Tony Silvestri on the application for Fireside Farm. As you just said previously, the Inland Wetlands Commission approved our modification to the inland wetlands permit for the relocation of the driveway to serve the 5 lots in the subdivision. There was a couple of outstanding items that I had an opportunity to speak with staff today. In particular, is some of the notations which need to be corrected. There's some spelling errors and typo errors, things like that. And we had a discussion regarding the inland wetlands notation on the maps. When these wetlands were delineated, they were delineated in 2010 by Mike Schaefer. Mike has since been retired, living down in Florida. And I did have the opportunity to speak with him this afternoon, and he does not recall doing the job, and therefore would not agree to sign the plan as indicating that this was the limits of the wetlands as he remembers delineating them. So if it's a requirement of the subdivision regulations and for that to have a live signature and certification that those are the flags as he delineated them, we're not going to be able to meet that requirement. Mike Schaefer is not going to be able to meet that requirement. So I'm not sure if that's an actual requirement of the regulations that they require a live signature. I do want to make a note for the record that the Inland Wetlands Commission reviewed this, I believe it was in August, and approved it, and then again last evening. And there wasn't a concern about the location of the wetlands or the fact that there was not a live signature by the soil scientist.
I
think. I'm sorry. Go ahead.
Oh, I was going to say I would ask Juliet to confirm that for us, but I believe that we are allowed to, if needed tonight, to close the public hearing, and table the decision if we need to, or approve it with a condition that is done if it's required.
You can also waive requirements in subdivision as long as it's not in your zoning regulations. Having a live signature to me should be required, but
yeah,
given what I've seen in your regulations, it may not be. It should be.
Juliet, is it a requirement in your regulations that the plans need to be signed by the soil scientist for delineating the wetlands?
Your guess is as good as mine.
To be honest with you, I don't recall seeing it in anywhere in the subdivision regulations, but
I was looking at the site plan. Hang on. Well, I mean, there's always the blanket clause in any zoning or subdivision regs is you can require any information to verify compliance with the regs, which is, I guess, why I always feel like if you're going to put somebody's signature on a plan that's verifying certain information, it should be their live signature. But I'm going to defer to the commission on that because I know there's some deficiencies in that regulation. So,
okay. We can save
Well,
that
like
for
I
the
said,
discussion so you can continue here.
okay. Well, if it was not a requirement, that's why I was wondering if it was actually a requirement by the regulations that even that notation even be on there, because if it's not, we'll just remove it. So the other thing that we were discussing with the Inland Wetlands Commission was, as you know, because this is a conservation subdivision, we're doing a shared driveway to service these lots, but as part of your zoning regulations is a requirement that you demonstrate that you could put the potential for lots to service each one of the houses. We did provide an exhibit that showed both potential driveways for the interior lots, which would be 36 Village Drive, and then the lot in the back, which is 34A Village Drive. There was an exhibit that we provided that showed a driveway and the amount of wetlands impact that it would have as far as the crossing of the wetlands, in addition to any drainage pipes that would be required. I can't speak for the Wetlands Commission, but I did get a couple of nods saying, they understanding that that's the reason we're doing a shared driveway is to avoid those potential impacts. And they didn't seem, I mean, I can't speak for the commission, but I believe we've demonstrated that we could support individual driveways to both of these lots. And as I pointed out to them at the meeting last night, and I think I pointed it out to this commission as well, that, you know, these lot owners are going to be bound by an agreement that they're going to have to share the driveway. If one of them should decide, you know, heck with the boundary line, heck with the agreement, I want to try to put my own driveway in, they would require inland wetlands approval as well as planning and zoning commission approval, because it would be a modification of the approved subdivision. So there would be some jurisdictional requirements if they tried to do that. And I don't think that would happen. I don't believe there was any other outstanding items. I know Juliet had provided me with a with an email again later this afternoon with some conditions that she would suggest if the commission was inclined to approve this. And I'm not sure if she'd like to go over those items, or if she would like me to do it, or how you want to handle that.
I can just show them to the commission. I actually have a potential compromise on the wetlands things. Since you have to come back for individual site development, that single family house is going to require a live signature and seal from the professionals preparing the plan, which means you're going to have to show it then for the house plan. So that's when you can flag the wetlands for the properties that are impacted by wetlands. So,
If that's necessary, we could we could do it if that's what's going to be required. By the way, I can see myself now in the camera.
yeah. All right. Can you see those?
See, now you turned me off and you put Juliet back on.
Sorry, I'm sharing the screen. You can toggle, you can put a, up on the top, you can pick that icon that looks like a checkerboard and you might pop back up, but these, if you can see those.
Okay,
So, yeah, these were just surety estimates for, you know, soil and erosion control, the driveway construction. There's a road being constructed as well, you know, the cul-de-sac. And some monumentation required along the open space and along the shared driveways. That's spelled out in your regulations. So I wanted the estimates to be in place before the Mylars were filed, and then the actual bonding in place before the zoning permits were issued for individual lot construction. I had felt that there was more grading that should be shown for the driveway serving 34A Village Drive, because it comes right up against those wetlands and there's a little bit of a dip, and I was curious how it was going to be filled. That could also be shown on individual site development plans easily. It's going to have to be shown then as well. And then all the legal descriptions and documents are based on they were based on the first set of plans that was revised, I think, to September something, but we since added a lot, changed the location of the driveway a little bit. So those draft deed descriptions, easements, driveway maintenance plan, open space description, I think that's it. They all just have to be updated before the Mylars are filed, at least the drafts.
Absolutely. Yeah, that's not a problem.
And then there's an existing zoning violation of a construction trailer that was supposed to be removed, I don't know, 10 years ago now, but Mr. Silvestri has stated that he'll use the construction trailer as he starts to, you know, as the houses are being built. So we've requested that he come in and fill out the proper zoning permit for that. And you can disregard the live signature scientists if you want to at this point, but like I said, for the actual single family house plan, I'm going to require that on our end, so.
well, it sounds
Yeah,
like since, oh, go ahead.
No, I was gonna say, all those items were agreeable to. And we, like, as Juliet said, we did provide all the deeds for the open space and for all the lots, and then we changed all the boundary configuration. So we you know, typically we wouldn't provide deeds until after it was approved. So we certainly will give all those to the staff before they're recorded. It's not a problem.
And who is the open space being deeded to?
That would be the town of Ledyard. That's the other adjacent open spaces are all the town open space. So this would be the same.
Okay.
Okay, so should we, do we have any comments on this before we close the public hearing and have a discussion? Unless there's anything more that you wanted to present, Jim?
No, that would be it.
Hearing none, I think we'll go ahead and close the public hearing on this so that the commission can deliberate.
It's 8:39.
It's 8:39. Now, do we start with the motion and then deliberate, discuss?
Yes.
Okay, so do I have a motion?
Madam Chairman, Tony Capon, I would ask Juliet to read the motion into the record, and then I will make that motion.
Okay, motion to approve PZ number 21-10 resub Fireside Farm 4-lot resubdivision 34 Village Lane with the following conditions. Survey surety estimates for the road and driveway construction, soil and erosion control measures, pipe extension under the driveway. All monumentation and final site stabilization must be provided prior to the filing of the Mylars. All bonding shall be in place prior to the start of the road or driveway construction and the issuance of any zoning permits for individual lot construction. All proposed new grading must be shown for all driveways. Provide indemnification note on final plans and deeds per 14.8C. Draft legal descriptions, documents for all new and modified existing lots, easements, driveway and utility maintenance agreement and open space must be updated, reviewed and approved before the Mylars are filed. The existing construction trailer must be removed prior to the filing of the Mylars unless a zoning permit is secured. And I will leave off the soil scientist one.
So moved.
Do I have a second?
Yeah, this is Paul, second.
Thank you. Discussion? Does anyone have questions or concerns? Maybe we could look at the plan again, Juliet.
Is it there?
Yep. So I think we're all pretty familiar with this. We've seen this for a number of months now. And I think the final arrangement for open space is good. I know we modified that from the original plan. You know, and with all the proposed amendments, I think we're in good shape to approve this, if everyone agrees. Okay.
Wow.
Wow. Okay. Any modifications to the proposed amendments? Do we need to say that the open space is being deeded to the town in that amendment, or does that cover it in the way it was worded?
No, it'll be covered in the language of the, I mean, he stated it for the record and it'll be in the deed.
Okay. Then I guess without objection, I'll call a vote. Vote to approve the motion. Tony?
Yes.
Paul?
Yes.
Tom?
Yes.
And Commissioner Scanlon votes yes. So we have a unanimous approval.
Okay, thank you.
Thank you. All right. Then it looks like we will go ahead and move on to the next site plan application. PZ 21-12 site. It's for 1528 Route 12, Gales Ferry, Connecticut. Owners Ledyard Land Group LLC, 59 Morning Dove Trail, East Windsor, Connecticut. Applicant Patrick and Sarah Scully, 10 Hillcrest Drive, Waterford, Connecticut, for a new 40 by 60 tap room, new 40 by 60 fabric building, parking, landscaping, and all other associated site improvements. Zone is the Gales Ferry Design District. Lot is 3.83 acres.
And we got a new exhibit. I think the new exhibits since the last time were exhibits 10, their responses to planner comments, exhibit 11, legislate approval, and exhibit 12 is a full set of revised plans to 12.9. And I will add the letter from the wetlands, which also forwarded a favorable report on, it was approved on the 7th. And I believe those are the newest exhibits since last time.
Okay, do we want to review the responses to your comments, or?
I was gonna let Seamus.
Okay, yeah, let's go ahead. Oh, sorry, I didn't see you there.
No problem. I was hiding for a little bit. Good evening, Commission. Thanks for having me again. Thanks for your time tonight. My name is Seamus Moran. I'm a professional engineer in Connecticut. I'm representing the applicants, Patrick and Sarah Scully, for their project located at 1528 Route 12 in Gales Ferry. So we did present this at the last meeting, PZC meeting on November 18th. There were no real questions raised. The few questions that were raised, we were able to address during the meeting. There were no pressing plan revisions required. Juliet did provide some comments in a memo for that meeting, which we didn't discuss at the meeting. We handled them after the meeting with Juliet. That's the responses that were forwarded to Juliet, which you see before you. So there were 10 comments that we can go over briefly. I think the only difference between the plans that you saw last month and the plans that are before you now are to address some of these minor issues. We did receive approval from Inland Wetlands on Tuesday, like you had mentioned. We're holding off on submitting revised plans in case there were any conditions for the Inland Wetlands from the Inland Wetlands Commission that we wanted to address. There were no conditions for that, so we submitted the revised plans this morning, or I guess this afternoon, and that's what we see before you. So you haven't had a chance to review them, but I think the changes are pretty minor, which we'll go over now. So the 10 comments that you see before you, comment number 1 that Juliet had was an additional detail for the proposed lighting needed, including the height of the poles for the uplighting near the entrance. Actually, if I can take a step back for a second, when I drafted this letter, what I had suggested to Juliet is, hey, can we hold off on making these plan revisions until we have any determinations and comments back from any of the reviewing agencies, PZC, Inland Wetlands, DOT, anybody like that. And she suggested that we should just make the plan revisions so that way we are reviewing the plans before you. So what you'll see in the responses are that I'm saying what we will do is this, and what that's actually been done, and that's on the revised plan. So it's a little confusing. The response was last week and the plans are submitted this week. So that's why the responses you see here are saying we will do this when it's been completed. I'm sorry. So the response to Juliet's comment number 1 is that we added a note on the plans that the poles will be 14 feet in height. The total light pole height is 14 feet, I'm sorry. And we provided a photometric plan to Juliet as well. I don't believe that was in the record, but that was provided digitally last week, I believe. Juliet, maybe you can confirm that. If I didn't do that, I'll send that to you.
Juliet, you're
Okay.
muted.
Looks like she's still muted. Anyway, so if I didn't
The
submit it
plan did-
digitally, I
Seems the
provided
plan
a hard
did show
copy.
up. It did show up and it was attached to the letter, so I
Okay.
think the commission has seen it.
Excellent. Okay. The only other, so in item 1, the uplighting, the uplights that is being referred to is the uplighting for the proposed or the future proposed sign. We wanted to account for something. We're not sure if that sign will be, that sign has not been designed yet. We just wanted to account for a future sign. But because it will need to go for a zoning permit, we're not sure how it will be illuminated. I'm sure it will be an external illumination rather than internal. I don't even know if an internal is allowed. But if it's external, we're not sure if it'll be gooseneck fixtures on the light or if it'll be some uplighting on the sign itself. So we just removed the uplighting altogether from the plan for now, and we'll submit that with the zoning permit for the sign when it's complete. Excuse me, item 2 that Juliet had was the corrected signature block should be provided. We had a little typo in our signature block, so we corrected that. Item 3, color renderings should be provided. 1 color rendering was provided showing the front elevation. Oh, there's a photometric plan. And there's the elevation. So that's the color rendering. It's somewhat similar to what will be there. I wouldn't say it's exact, but this is an artistic impression of what the front will look like. So I believe that was item 3. Yeah, that was item 3. Item 4 is it says the southern central portion of the site of the parcel appears to slope sharply toward the gravel patio area where the septic system is to be located. The proposed under drain does not appear to extend to that side. Will the proposed bioretention area capture all of the runoff from the hillside? So there is an under drain, like we discussed at the last meeting, that's on the eastern portion of the site. It wraps around the southern side of the fabric building, so it captures a significant portion of the steep hillside and reroutes it to the north. The portion of the hillside that is not captured will be redirected in a gentle gravel swale around the backside. So none of the runoff that's coming from off of the property will be going across the parking lot and into the bioretention basin. We're trying to redirect that around the development area. So that should answer that question. Item 5, the food trucks do not appear to be handicap accessible. There's no ramp on that side of the building. We did add a handicap ramp in the sidewalk to provide access to between the food trucks. Comment number 6 was add a legend to sheet 6, which we provided. Number 7 was no loading areas provided. So the loading will be, so we added a note to the plans that says loading or unloading is to be provided during off business hours in front of the building. So I believe that was site note number 19 that we added in the latest plan set. Comment number 8 is though not mandatory, the design guidelines specify no chain link fences. So what's on the plan is a proposed chain link fence, and that's required for the use to separate, since it's a dog friendly facility, they have to separate where it's dog friendly and where it's dog unfriendly. And the fence is proposed to do that. We feel like the chain link fence matches the industrial look more than say a stockade fence. But that's a discussion we can have if so be it. Item 9 is identify the location of the nearest fire hydrant. So there's a fire hydrant 300 feet to the north and another one, north of the driveway, and another hydrant 320 feet south of the proposed drive. One thing to point out is we are proposing an 8-inch water line into the site. Once it gets to the building, it'll split to an 8-inch fire protection line. There will be a fire department connection on the building. And the buildings will be fit for plumbing. So for a future sprinkler system, it's not required for the code right now, but they do believe it will be required. So they're installing the plumbing for a fire sprinkler system, although it's not going to be installed, or it won't be connected right away. Item 10 is signage was not reviewed as part of the application and will require a separate zoning permit. Again, we're not proposing any signage. We'll submit a separate zoning permit application at a future date.
There's a photometric plan too that was attached to that letter.
So that is a summary of the changes since we last spoke and you last saw the plans. I think it was fairly de minimis, but I welcome any questions at this point if you have any.
The only question I have was, did you get any feedback on the sight lines from the entry?
We haven't. We actually submitted to the DOT on November 15th, and I checked in 2 days ago, and they still haven't reviewed it yet.
Okay.
No, unfortunately.
Is there already an apron there?
There is no apron there already.
I can
Yep.
see the new ramp there. Yeah. Mhm.
Yep, there, the loading note.
Um, do any commissioners have questions for the applicant? Okay. Do we want to make a motion?
I mean, that's a simple motion. I didn't even have any conditions because it's one of the better site plans I've ever seen.
Yeah, look, I mean, it's very complete. I have no questions. And all the minor items you just addressed in that list there. And it was a good move to just remove that uplighting until you're going to submit for the signage anyway, so that we don't have that outstanding question.
Thank you.
Yeah.
So I mean, I would say that all required bonding should be in place prior to the issuance of a zoning permit.
Okay. And do we want to say anything about the DOT sightline? Or that will be for it to get built, it has to get approved.
So do you have an encroachment permit?
No, we don't have anything from the DOT right now.
But you applied for it.
We haven't applied for the encroachment permit yet. We just submitted plans to them for review for the sightline. The encroachment permit is for the construction. So I don't believe he's submitted the encroachment permit yet, but he's not on the call. I just figured he'd be waiting for it to be approved, the sightlines to be approved before submitting for that.
So I can add anything to this if you want.
I think it would be reasonable to have DOT approval of proposed sightlines for curb cut, or however you apron.
DOT's always been kind of interesting on that subject. They want to see an approved site plan before they'll even entertain an encroachment permit.
Right.
And as planning and zoning, we like to see the encroachment permit before we approve the site plan. So it's
a no-win.
A zero sum.
They won't approve it until we approve it. So it's nice.
Yeah. So this is assuming that they approve it, because then if you have to do significant changes, that would change the site plan, and then it would require coming back. So maybe it's irrelevant to even have that line item if that's the case.
But we can say prior to issuance of a building permit.
Okay. That lets you
give some time.
Yeah. They're supposed to get back to you in 2 weeks, but
oh, not anymore. That was pre-COVID. It's 6 months now.
Good luck.
6 months.
No.
Okay.
Make that better.
famous on a non-condition of approval. We ran into the same issue on chain link fencing when we did the Ledyard Town Hall Police Station and ended up compromising on welded wire fence. It's still black. It's still vinyl coated. It still has the same spacing. It's welded wire and it looks much fancier. I don't know the cost differential, but that may be something for you to consider.
I've actually used that on very high-end residential handrails for a porch. It looks like the small cattle panel, or animal panel.
Yeah, that one.
But it does look nice. So maybe that would be a good solution. I don't think we need to make any note of that, do we?
No, and I think it's more durable. I know the chain link fencing like I put around my pool, I need to re-stretch it once every couple of years because it tends to stretch, but the architectural welded wire panel type stuff doesn't. It's stronger.
Less maintenance.
Yeah, I can certainly bring that up to them and the architect and see how they want to move forward as an option. Welded wire fence.
All right, so then would anyone like to make a motion?
Once again, Madam Chairman, if staff will read the motion into the record, I will make it.
Motion to approve site plan application number PZ 21-12 of Patrick and Sarah Scully for a tap room, fabric building, parking, landscaping, and all other associated site improvements at the parcel located at 1528 Route 12, Gales Ferry, Connecticut 06335 in the Gales Ferry Design District with the following conditions. All required bonding for stormwater management systems and soil and erosion control measures / site stabilization shall be in place prior to the issuance of a zoning permit. Connecticut DOT approval for proposed driveway sightlines / encroachment permit must be secured prior to the issuance of a building permit.
I will second it. So then I'll call a vote. Tony,
Yes.
Paul,
Yes.
and Tom,
Yes.
and I vote yes. So unanimously approved.
Thank you very much. I appreciate your time again.
Thank you.
Bye.
Good night. Thanks.
Good night.
Right. Forward those to you.
So I believe that concludes our new business, or no, our application portion, and we go to old business. Do I have the right information on the agenda, or did we include the bylaw revisions?
That's under new business.
Okay. Okay. So old business was discussion on new legislation regarding housing ADUs. Just continuing the conversation that we had last month regarding the new state statutes that got put in place. Was there any prepared information on this that I missed, or is just continued conversation?
Continued conversation.
Would any commissioners like to speak? I have something short to say if no one else does. I think the timing of the short-term rental addition to our zoning regulations is good, because I do think after thinking about it, you know, allowing short-term rentals in owner-occupied homes actually makes housing more affordable in Ledyard, because it allows the owner of the home to rent space that they're not using to offset the cost of their housing. So I think, I'm not sure if there's any provision in the state count of affordable housing, but if we were to count up the owner-occupied short-term rentals, I wonder if that would be any consideration toward Ledyard having affordable housing.
Would not count.
Okay.
But it
Not
also
as
doesn't count,
qualified affordable.
but it also doesn't count as an additional dwelling unit. So,
Right.
so it doesn't count on either side of the equation, which is good.
It doesn't work against us if we approve, or if we have accessory dwelling units. And it would provide, like, for the you know, the idea that the short-term rental has to be the person's primary residence, you know, if they did have an ADU, even if it was detached, then the owners could, like, you know, hang out in the apartment while they have somebody in the house, you know. In my provision, I didn't allow the short-term rental to be in a detached accessory unit, but the owners could go there
And why do you think that that's necessary?
to prevent them, the accessory apartment from being used.
Mhm.
Well, I guess I mean, I personally, I don't care. But if, since accessory dwelling units didn't seem to be wildly popular with everybody, and the idea was that the house be, I don't know, I guess I don't really have an opinion.
I was just curious because I remember that did come up in Eric's presentation for his proposed zoning change, and I will be recusing myself from that because I did have a short-term rental prior to COVID and all that going on, and I did rent an in-law suite at my house out, and we lived in the main part of the house with more bedrooms and rented the in-law suite prior
That's
to their,
attached though, right?
yeah. It's
No, that was
attached.
okay, where I was saying detached. If we ever did allow a detached accessory dwelling unit, you know, would we care if either the main house or the accessory unit was used? And I will, before
Well-
Eric chimes in and says it, I will remind you that a trailer, like a mobile home, would not count as an accessory dwelling unit. It's too big. The statute does cap it at 1,000 square feet. So.
I think it's interesting because I think renting either an accessory dwelling unit or an in-law suite has a lower impact. It's sort of, you know, there's only going to be 1 or 2 guests. There's not going to be a larger family or multiple, you know, cousins or whatever coming together, or, you know, certainly not any larger groups than, you know, 2 people and a baby or something like that.
Yeah, I agree.
So I was just curious about why there might be a reason, other reasons I'm not thinking of, why that would be, you know, a risk to a neighbor. But so do we want to have a discussion about detached accessory dwelling units and how the commission feels about that?
Katie, Mike Cherry, when we modified the 8.1 section of the current zoning regs from in-law apartment to accessory apartment, we couldn't reach a consensus on whether we like detached accessory dwelling units or not, so we left them out. We said, okay, let's just go with the attached ones, and we won't do detached. We'll leave that for a future date. I'm kind of in agreement with our town planner. I'm ambivalent. I think if it's attached or detached and it's done correctly, it doesn't impact the dwelling unit. It doesn't impact the use. Does it fit on the lot? Doesn't it fit on the lot? The other thing that precluded it in a lot of cases was health district rules, septic and water. And it appears I haven't delved into that new section of statute, nor have I seen what the health district says, but it looks like they provided some relief on you can hook your accessory dwelling unit up and not have a community sewage system. So, you know, that's going to play out. And that had a big influence on why we said no before. It was just too expensive.
It provided that the system is big enough to handle whatever the total number of bedrooms are.
Correct, correct.
And remember, you know, you do have a housing crisis going on in southeastern Connecticut. There's a dire need for rental housing. This is a way to allow more density without more sprawl. And, you know, you have lot coverage rules as well. You can only cover a certain percentage of your lot with impervious surface, health code. You guys prohibit things in the front yard. Not sure why, but right now you do. You know, so there's a lot of limits. So not everybody could take advantage of this, but
And there's still a size restriction on the accessory dwelling unit, whether it's attached or not, right?
They did put a size restriction on it.
Yeah.
They're good. I mean, I've never, in all the years of my planning, have not had issues with accessory apartments, whether they were attached or detached or a lot of them end up over a garage, you know, there's nothing wrong with that. The building's already there. You know, I don't know.
There historically hasn't been a large demand, and it may be because it just wasn't allowed, but my experience is people don't read the zoning regs first. They come and ask if they can do it first. And we've had one or two a year where they would like to build a detached accessory dwelling unit. So it's not been a popular thing. Juliet made a good point that when she mentioned that there's a dire need for housing in the area, the other subtle change to the statute is we're now enjoined to look at the housing needs for the area, not just our municipality. So that gets us wrapped in more with Southeastern Connecticut Housing Authority and COG reviews on how much housing is where. So we can't just look at Ledyard, we have to look at the whole area.
Considering that there is a low demand for it and, you know, but there is some interest in it, I don't see personally any reason why we would prohibit detached accessory dwelling units in the
Oh, and
future.
the other reason for them, I think COVID had a little bit of an impact too. Before I came here, we had a serious uptick in applications for ADUs in North Stonington because they wanted their relatives close to them. You know, the elderly relatives, they wanted not out of the nursing home and into the house. You know, so it did COVID has played into it, and then some of those areas are also used as a home office. So.
Katie, I'm with you. I don't see why we would have a problem with attached or detached. It's certainly something we should consider.
I really like the idea that it could increase our available housing stock without impacting the character and nature of Ledyard. I know we can't use that word character anymore, but you know, something like an apartment over a garage or, you know, something like that is, you know, typical and traditional, you know, in a rural setting. And I think that, you know, we'd have to take a look at the regulations to find out and make sure that we've got, you know, everything covered that we want to have covered in this, particularly the smaller residential zones, smaller lot size zones. But I think it's worth considering.
The whole topic is certainly something we have to consider next year. We know that.
Juliet, which comes first, the housing plan, the affordable housing plan, or regulations for ADUs and such?
Well, I've already written them into the draft I'm providing, so I don't know.
We're going to get those first.
Yeah, you probably will get those first.
Do you have, sorry, did you say that there's proposed changes for to meet the affordable housing requirements already being done, or the short-term rental impact?
I'm working on making some significant suggested changes to your regs, but since we have to address the short-term, the accessory dwelling units, you have to provide for them. So I'm sort of playing with that now, working them into your regs. So there's a few things you have to address. Like I said, that the character issue, the accessory dwelling units, the parking, we can't require certain parking, and no minimum apartment sizes and things like that. And some changes to your multifamily regulations as well. So all of them are on my radar and making their way into the draft that I'll be presenting at some point when it's finished.
Thank you. All right, so then unless we want to continue this, maybe we could move on to new business. The clock is getting further along here. So we do have some bylaw revisions to make based on our conversation last month. And I hope everyone's had a chance to take a look at it. So I would make a motion to approve the proposed revisions to Article 1, Section 2 and Article 3, Sections 2, 3, 4, 6, and 7 of the Planning and Zoning Commission bylaws, and to update the approval and effective dates as shown on the document prepared and submitted by staff. So these are the changes. I think the perhaps the largest change would be that all votes shall be by roll call, where before it was only by request. And that's just with, you know, voting via Zoom. There's no real way to have that in the record if we don't do a roll call vote. And it's just easier to find later.
The November,
we can have it either in November or December.
Yeah.
Right.
Our annual meeting, just giving us the flexibility depending on.
And you don't have to hand deliver to each commission member.
Yes, now we can
their
be
business.
electronically notified of
Do it
ours.
electronically. We're in the 21st century.
Yeah.
I'm glad to see that one change. When a quorum is in, what is this? When a quorum is in attendance, action shall be taken by the commission upon a majority of all voting members present. Yeah, so just cleaning it up a little bit, and then the We added
agenda.
this to the agenda as well.
Yes, the pre-application workshop section, and just reports in general. And
that was it.
I believe that, and then yeah, so these are the effective dates. So it would be adopted today and effective on February 13th, 2022. Does anyone want to discuss, or I think I need a second on my motion, actually.
I would make a second on that, and I do have a comment.
Okay.
I notice in the order of business, the second order of business is a Pledge of Allegiance. And I don't remember doing that since we've had our Zoom meetings. I think probably somebody should be able to put us up a flag, and we could do that in the future meetings.
You're right. That has fallen off the agenda since we're no longer in person.
You should, talk about that, because I think the idea is that we all go to hybrid meetings. So I'm not sure if the mayor's gonna put something out there about that, or if you're gonna stay on Zoom, but think about that as well.
Yeah, but we can put up a flag and
Yeah, there's probably a Zoom background available or something.
Yep.
We'll all stand up and you'll see us from the,
belly button,
belly down.
Keep that
We're
in
not going to
mind.
be able to understand anybody anyway, because there's going to be so much feedback with a dozen people all speaking simultaneously on Zoom. So it'll be an interesting sound.
Or just mute. All right.
Okay, so did we want to change anything about the Pledge of Allegiance? Do you think we can really do it on Zoom, or should we say optional Pledge Allegiance?
we can do it on here with the Knights of Columbus. We do it all the time.
Okay.
And sometimes you just mute some of the mics. That's all.
Okay.
Just pick one person to announce it
There you go.
for the group.
Yep, that works too. Have one person do it for everybody.
Sure.
Okay.
Did
Then
you wanna
I'll
vote?
call. Yes,
Yeah.
please. Okay, Tony,
Yes.
Paul,
Yes.
and Tom,
Yes.
and I vote yes, so unanimous approval. Excuse me, I got a cough here. So then we need a approval of the minutes from November 18th. Do I have a motion? No.
Make a motion to approve the minutes of November 18th, Tony Capon.
I second. Paul?
Thank you. There's no amendments that I know of. So then I'll take a vote. Tony,
Yes.
Paul,
Yes.
Tom,
Yes.
and Katie, I vote yes, so that they are unanimously approved. Do we have any correspondence?
Yes. You have just the letters that came from town council congratulating Mr. Alrock. I don't know how to pronounce your name. I'm sorry. Alrock. James, I don't know. Can you pronounce your last name?
I think he's checked out, but it's all right.
Yeah, no, I'm still here. That's
Okay.
that's it.
Hi, sorry.
How do you say your last name so I don't butcher it?
Oh, that's okay. There's a gazillion different ways, but it's actually pronounced Arak.
Arak. Okay. That was a letter from council there and a letter saying that Councilor Tim Ryan has been assigned as a liaison to the Planning and Zoning Commission. What you've got. Katie, you muted again.
Sorry, I've been coughing.
Oh. That was all the.
Okay. And then for reports, town planner report.
Since we met pretty not too long ago. So I don't have a whole lot to report other than well, actually I do have some exciting news on the building department side. In a 3-day span, they approved $1 million in construction value. That's
Wow.
pretty outstanding, I thought.
Nice.
Oh, a mix of residential and commercial, or mostly commercial?
Mostly residential, I think. Wasn't
Wow.
it, Mike?
Mostly additions, yeah.
Wow.
And some houses, obviously, but
I could be a smart and say, yeah, that was 2 homes, but no, it was quite a few.
I think it's 4. But still, that's a pretty big number for 3 days, I thought. So that was good news. I did submit an intent to apply to that community, I'm blanking on the name, Connecticut Communities Challenge Grant to pay for a portion of the sewer line going under the multi-use path. It's a very complicated grant. I'm not entirely sure we're quite ready to apply, given what I'm reading on the grant, but hopefully we can get through that one and get some funding so more of the ARPA funding can go towards another phase of that sewer line instead of under the path. It's budget time, so I'm working on that. Nancy and I are getting up to speed on iCompass, and now I have to learn ClearGov or something for the budget process. So at least I'll be much more tech savvy at the end of my time here with all of these new softwares. The first phase of that GIS update is complete. So we have some new tax maps now. The shape files now have to go to people GIS to somehow miraculously get updated, although there's still some issues with some of the maps that he was given. So right now we're trying to figure out how to continue on that process so that these maps are up to date. It's really it just has to happen. And we're having a conversation today about the wetlands maps at all, which is why I'm pretty insistent that these plans be signed, you know, have an official signature of a soil scientist, especially if they were created over 10 years ago. I mean, that to me is crazy. So we have to come up with a way to get that data to a GIS person and get our wetlands maps updated. So I'm starting to research if there's any other way or something I don't know about, some DEP database that we could tap into to update our map, something, but it's so out of date that it's just really not useful. So I'm continuing on that. And then we had an issue with our deed restricted units. The state wasn't recognizing that we had any deed restricted units, but you had 6 of them. So I've sent everything that I could find to the state rep, and 5 of them should be fine, but there's one on 6 Ledyard Lane is now in violation of their affordability plan, and I have no idea what the enforcement there is. So I have to call Mike Santoro from the Department of Housing to figure out what we do, because it's supposed to be owner occupied, and I guess they tried to sell it but couldn't, and then moved out of town and are renting it out. And 83 Inchcliffe, which is a rental unit, which is supposed to be certified every year, isn't being managed by any company, which is bad. So, because there's certain requirements of advertising it to renters and, like I said, recertification. So I'm trying to get to the bottom of that. But when I get to the bottom of all that, your percentage of qualified affordable housing will jump up considerably. I guess that's, nothing really else is exciting. I mean, we're just busy with meetings, busy with grants. The steep grant is progressing along pretty well. We're actually getting to the bigger projects in that, the pole barn roof, and getting the cement poured for the picnic tables and whatnot. So that's going along. The sewer study is about 95% complete. The housing plan grant, we only got one response to the RFP, and it wasn't the Council of Governments. So I'm confused, because they said they would have responded, but the group that has responded has done several of the plans in the area. There's the 2 principals are people I know quite well, actually, so it's fine if they end up being the ones to help. So at least we got one, so we can get that moving along. And then I'll turn it over to Mike.
Once again, it was a short week. I was out the week of Thanksgiving for cataract surgery, so not a whole lot. Lot of temporary sign problems been going after. You'll notice Spirit Road Church had all their signs up. They got the cart ahead of the horse. All they had to do is let us know they were putting up signs for their service. So I did talk to them, and she sent an email. Blight and junk, repeat performers, people that were bad, cleaned it up and really looked good, and all of a sudden you get another complaint, and I look through the records and look at the pictures and say, no, that was cleaned up. Then I go drive by, and it's worse than it was when the original complaint came in. So going back after those repeat offenders. Zoning permits were down, but certificates of completion. Katie's starting to live in a neighborhood.
Yeah.
Oh, yeah.
Yeah, we completed 3 more there, and signed off permits to build 2 more. So, that's moving along quick. I got to holler at the developer and say, he could be magnanimous and plant a couple of trees, but the homes are nice. I did work with the town council admin committee, trying to get some words for enforcement. I kind of like where Eric and Juliet are taking us. I think that's easier for enforcement, but I think Juliet's right. There may be too much granularity in Eric's proposal to be enforceable. It may take too much time. So I trust the commission will get to the right answer. Still verifying the record on closeout actions, then a couple items of interest. I got a call from one of our cemetery managers asking about green burials. That's burials without a coffin, without embalming, without a concrete fixture. And as near as we can tell, it's kind of sort of allowed in Connecticut, but nobody's doing it. So, and then the other one for you to consider as you look at regulations is the 80%, an accessory structure needs to be no bigger than 80% of the principal structure living area. I mean, it's an unfortunate circumstance, but somebody applied, they bought a building, $60,000 worth of building, and it's 150 square feet too big to hit the 80% limit. Luckily, he hasn't constructed it yet, but do we want to stick with that accessory no more than 80%? That's up to the commission to decide what we want to do going forward. And that may be important as we look at detached accessory dwelling units.
What
and
zone
we
is?
start adding that up with sheds and pools and other accessory uses on the property. It adds up pretty quick. That's all I've got. If anybody has any questions, happy to answer.
So you're saying the application is for a accessory dwelling unit attached and it's just a
No,
little
no.
larger than 80?
He was building, he used to be a contractor. He's retired and he has some favorite toys that he has out in his yard and he wants to put them under a roof. So he proposed 2,000 square foot garage type structure.
Mhm.
Which is
Well,
suspect always.
it always is. I used to be a contractor, honest, I'm not anymore. Can I build this huge garage?
Mhm.
He's next door to a larger parcel that is doing horses and has a barn of about the same size. So probably never even dreamed that his huge building was going to be a problem. But it's 150 square feet too big to meet the 80% rule. So they're scratching their heads trying to figure out how they can reach more livable space or maybe go remeasure. I just go by the street cards up in the assessor's office. It's this big,
You can put on a covered porch.
That's what he's looking at, a covered porch with screens or something to make it a livable area. But it's always interesting.
Or put a tractor in there and call himself a farm.
He's not quite big enough.
No.
Regarding the violations for short-term rentals, and I didn't want to mention this in the public comments specific to what we're bringing up, but I know because I used to use both Airbnb and VRBO to list my unit when I rented it. They both require you to sign something that says that you are complying with your local regulations.
Yep.
I believe there's a way for you to contact Airbnb to tell them that this person is not complying, and Airbnb will suspend their ability to rent.
I think the mayor has actually reached out to one of the directors at Airbnb somehow, and he was part of a conference or something and said, if you have any questions, call. So the mayor called and didn't really get any adequate response, but I'll close that loop with him again, because he did mention that he had some either email or phone number or name or somebody to contact. So
I think there's a way directly on the website to report a listing.
There is.
Yeah, so if there was a real problem, those problem listings, you could report the listing direct.
well, there are two. Both were discussed tonight. The one on Pumpkin Hill Road and the one on Eska Drive.
Yeah, so either that neighbor or you could.
And there's the ones on Shoeville, or it's either Shoeville or Iron Street are not. not permitted. All the
have to-
non-permitted ones, we could try to find a way to report them.
Yeah, I had
Because,
trouble with that one because I couldn't figure out what the address was until I finally drove by and said, okay, it's these two white houses almost on the corner. I don't know how the address has changed, but that screwed it up for a while.
it's Airbnb's way of getting out of the liability, because they don't want to be held in court for people that aren't complying with the local regulations. And so they make you sign it, and that's a part of your listing agreement, that you use their services and that you're compliant with any local regulations or ordinances.
Yeah, and I guess the other thing for the commission to look at is go back and reread your definitions and your lawyer things on legal nonconformities. If we do this by zoning regulation, we need to look at who is pre-existing legally.
Yeah, but you forget that ordinance sunsets, and those ordinance only allow you a 1 year. So after a year, they'd be gone anyway.
Yeah, for anything current, but there are some that date back to the 40s and 50s have been used for short-term rentals, unfortunately.
Also, it all seems to come back to noise, and I don't know why we keep having there's for some reason we can't pass a noise ordinance.
They're not enforceable. Noise ordinances they're not enforceable, period. Nobody's qualified on your staff. Nobody has the equipment to go out there and measure it, and we don't go out on Saturday nights and stuff. The police have to do their job. The police have to go out and issue tickets.
Yeah.
So the police can determine if it's too loud.
Well, and it, in a way, it's interesting because some of the information I got from Constable McGrattan was police blotter for the addresses that were non-permitted short-term rentals. And I didn't see anything that said noise or nuisance or road blockage. I saw animals, I saw medical calls, but nothing that I could relate to their use as a short-term rental, which was interesting because on the other hand, we hear the neighbors saying, we call the police and they come and they leave, and then the people go back to doing what they were doing before they came. So there is a disconnect there somehow. And, one of these days when I'm feeling up to it, I'll go talk to Lieutenant Croats and Chief Rich and see what information am I not seeing that would help us go do some enforcement. But, gets difficult. It's limited time more than anything else. And, got to move things along. So like I said earlier, anybody that knows anybody that's in, mid-career looking for a challenging position to where they can be on the forefront, deciding what Ledyard's going to look like in 20 years. I'm no longer advertising for commission members. Now I'm looking for staff.
I think he wants out.
Well, there are some good reasons why I'm going to have to, the tax laws are going to get me next year. So.
All right.
All right.
Been a long day.
And we don't have any other reports that I know of. We haven't had a regional planning meeting. The last
Katie,
one we
you
had
could-
didn't have a quorum.
Katie, you could ask Justin again to rethink his short-term rentals are best done by ordinance. He wrote the piece of paper that we asked for.
Yeah.
Maybe if we asked for a different piece of paper, we'd get a different answer today.
Okay.
The chair of the Regional Planning Commission at the time kind of said, boy, it'd be nice if COG would say this should be an ordinance. So they did. My bad.
In line with all the legal counsel that we had access to. So.
Yeah. But we're 2 years down the road now. And so is everybody else in the area, and things have been changing. And I think there's an explosion in people doing short-term rentals because it's gotten so easy. They're now advertising VRBO and Airbnb sporting events and everything else that you have on television. So people now see that as something viable, and it's always this beautiful place that you could never afford to have on your own, right?
Yeah.
So they make it inviting.
It's just we shut ours down with COVID. It was just not worth it, not worth
Yeah.
doing, you know, dealing with it all. And maybe one day we'll get it back up and running, but it's
Yeah,
kind of nice not having to do the work.
yeah, everybody thinks it's just a good deal. No, it's a lot of work.
No, people are looking for advice on where to go out to eat. They want to be friendly. Most people want to be left alone, but you do have to, you know, do the cleaning or hire someone and all that. So
Yeah.
anyway. All right. So if there's no other reports, and without objection, I'll make a motion to adjourn.
See everybody in a month.
All right.
Have
Good
a
night,
great
everybody.
Christmas, Happy New Year.
Merry Christmas, Happy
that's
New Year,
time.
Happy
everybody.
Hanukkah.
Yep.
All right. Good night.
Bye.
Good night, everybody.
Night.
No, there's a button on here somewhere.
I'll kick you out. Okay. How about that?
Thank you.
Bye-bye.